Good evening, everyone. My name is Kyle Nazareth, and I'm the president of Ohio Northern University's chapter of the Federalist Society. I will be your host for tonight's FEDSOC Study Break on the origins of the Supreme Court question selection. We would love for you to join in on today's discussion, so if you have any questions, please feel free to use the question and answer function in your Zoom window. Without further ado, I'm pleased to introduce Professor Ben Johnson, assistant professor at Penn State Law. Professor Johnson teaches Fed courts and corporate law at Penn State. He got his JD from Yale and a PhD from Princeton in political science, and he wrote a dissertation on the cert process. Professor Johnson's also a huge Baylor fan, and he and his whole family went to Baylor, and he wanted me to let you all know that Baylor's men's and women's basketball and football teams are the defending conference champions. Professor Johnson also met his wife on the third day of class, freshman year of undergrad at Baylor, and he has 3 kids. The starting point of this discussion is going to be a law review article that Professor Johnson wrote on the origins of Supreme Court question selection, which will be published in the Columbia Law Review. And we may also get to discuss an Alabama Law Review article written by Professor Johnson as well. So Professor Johnson, the floor is yours.
Well, Kyle, thanks so much for hosting this, and thanks to Peter and the FEDSOC guys for the invitation to be here. It's a real privilege and honor. This is kind of like setting up like a fun week for me. It's like the kickoff of my fun few days. So tomorrow we're our local chapter here at Penn State Law, the Federalist Society, is I'm doing an event with them and Josh Hammer on common good originalism, and then I'm going back to New Haven because every year my wife and I go back to see the Law Review show, like the end of year comedy show. Because so like when I was in law school, I ran the show my 2L year. And then I did the music my 3L year. And this is back when like people could be friends across the aisle and such. So both within our Federal Society chapter and like in the Law Review show are people who some went on to work in the Trump like White House counsel's office, and another one of our head writers was one of Mueller's team, like one of his chief prosecutors. And we were all in the same Federalist Society chapter and all in the same comedy show. But my wife and I go back every year for that. And so we're going back tomorrow night. The show's Thursday, and so this is like the first part of like 3 awesome days for me that I'm very excited about. So thanks for making this happen. Yeah, so I guess I should say just a little bit about this project and how it got started. So as Kyle said, I wrote my dissertation in grad school on the cert process. And every now and then you read something that just kind of like rocks your world. And there's this Columbia Law Review article by Ed Hartnett that basically tells the story of the Judges Bill and how the Supreme Court got enormous power over its jurisdiction. I knew that the Judges Bill was where this happened, but I didn't know the story of how it happened. And Ed tells the story very compellingly. And it turns out that the justices just straight up lied to Congress about what was going to happen. They just, I mean, there's just not a nicer or more like accurate way to put it. They just lied. And told Congress they were going to do one thing and doing something else. And I was very stunned by this. But the thing that really just kind of drove me over the cliff was like a short 1.5 page, like subsection in the back of the 4th section of his article, where Hartnett points out that the Supreme Court no longer actually decides cases, they answer questions. That kind of blew my mind. I went back and I looked at the statute, which is always a dangerous thing to do. And I looked in the statute, it says very clearly that the Supreme Court can take cases through certiorari and can take questions through certification. And I thought, man, that seems pretty clear that this is one or the other. And then you go look at the Supreme Court's rules and they say only the questions included in the petition will be reviewed. And so like the Supreme Court just straight up does not care about the statute. And that just blew my mind a little bit. So I was like, how did we get here? This seems weird. And so the article just kind of traces that story. And I think it matters for a few reasons, I think. So one of the things they teach you in like baby political scientist school is that the agenda matters. So basically, by the time the case gets to the court, it's pretty much over. It's cooked. And this is the book, the thing is done. The same is true in Congress and a whole bunch of other places. What you see at the end of the game it's already been decided beforehand. I think it also matters because like for kind of Federalist reasons. So if you go back to the Federalist Papers and the idea that the courts are supposed to have judgment rather than will, like what's the meaningful difference between those things? I mean, when you exercise your will, you're making a choice. Like you're applying your judgment to it. What makes the difference between judgment and will to me is that you get to choose where you're going to exercise your judgment. That's the willful thing, right? Like, I'm going to do this today. I decided today I'm going to go for a run, or today I'm going to work on this paper, or today I'm going to do whatever. And then I'll decide what I'm going to do once I'm there. But the will is deciding where you're going to show up and what you're going to spend your time on. And so the court has basically taken will for itself. The Federalist Papers say, look, if the court gets will, then you're better off without judges at all. You should just leave it all to Congress, because at least that's democratic. There's some problems with judicial review, and Hartnett points this out. In fact, Alexander Bickel pointed this out, that the reason Chief Justice Marshall told us we have judicial review and why it's okay is because, well, the court has to declare what the law is, because it has to decide the case. It has this obligation to decide the case, and in order to decide the case, it has to say what the law is. So to fulfill its obligation, it's like, I didn't want to declare law. I just had to. I didn't have a choice, right? But now they choose, right? Like, I don't declare law because I have to. I declare law because I want to. And it's not because I have to decide this case. It's not only do I not have to decide this case, I'm not actually deciding this case. I just cherry picked a question from this case, and I used it as an opportunity to speak some truth into the world. And I think that's dangerous. And I think it's also dangerous. I mean, there's a lot of talk about the court's legitimacy, and generally what that means is I don't like the way the court ruled in a case that I care about, and that's what makes a court legitimate or illegitimate, I think. But if you wanted to kind of, I think any sort of argument, what would really make the court illegitimate is when they hold other people to rules and standards that they themselves don't abide by. And there's a bunch of cases where, and things that look a lot like the statute that grants the court cert power, the court has held other people to very strict textualist readings or very strict originalist readings that if they applied to themselves in the cert process, they would have to do some things very, very differently. And so I think it's just, there's a legitimacy problem lurking here for the court if they hold other people to a sort of like set of standards and rules that they themselves will not live up to. And I think that's dangerous in the end. So I think that matters. It's kind of, and also just kind of interesting, like the history of appellate jurisdiction is something I never studied in law school, didn't know a lot about. And there's a lot of really fun, interesting history there. Most of it made it in the paper, but some of it didn't.
All right, thank you so much, Professor Johnson. Now we've reached the part of our show where we're going to do some Q&A from the audience. So while we wait for questions from the audience, I'll start off with one question I had. And this may be obvious, but it's kind of a general question of, is a cherry pick question a case or controversy under Article 3?
Well, that is a great question. And yeah. So I think the answer, because I'm a political scientist, there is one answer that is correct in almost all circumstances, and it depends. So let's think about what a court should do, and in fact, what an appellate court like generally does in the ordinary course, and is always supposed to do in the ordinary course. Let's take a case at law. You take the record and you review it for any legal error that would justify reversing the decision below, right? So suppose you review the record and you identify a question that requires reversing, and you see this as a question, and yes, we can reverse on this question, and we look at it and they got it wrong, and so we reverse. That would be fine, right? Like there's absolutely no problem with that, right? And in fact, 60% of the time the court like reverses. And so probably like 60-ish% of the time, that's okay. Now there's a wrinkle there, because a traditional rule in appellate jurisdiction, and the court has said this is true for the court also, but they don't really believe it, is that when you win below, you can defend the judgment below on any ground available in the record, right? So there's three ways I could have won this case. The lower court, said I won on C. The record also justifies A and B, but the lower court didn't get there. I should be able to go to the reviewing court and say, listen, whatever you think of C, I also win on A and B, and I should be able to defend the judgment on A and B that are in the record, especially if those are like decided in the record in some way. And basically, if the court just says, oh, well, you got this question wrong, and maybe it matters, maybe it doesn't, I don't know, but we're going to remand it, and you figure it out down there, that's not okay. Like, that's not okay. Now, what's really not okay is if there's like 6 questions that have to be answered in the affirmative to affirm the judgment below, and we'll look at one of them, right? That's really not okay, because you're basically affirming a judgment and you haven't checked to see whether the other 5 things are right or wrong. And if you wanted to get like super technical and formalist about it, you've actually made precedent on the other 5 things, right? Because these conclusions of law are necessary for a judgment of this court, which was an affirmance. Now the justice would say, oh, of course not. That's not real precedent. I'd be like, oh, well, insofar as you're saying that, you're admitting you're not actually doing the appellate court law thing. You just admitted that you're not actually an appellate court doing a court thing. You just announced that we view ourselves more like the Oracle of Delphi than, an honest to goodness court. And I think that's bad.
Well,
like how I dodged that question entirely. So is it a case or controversy? Maybe. But but certainly, I mean, they don't think it is, right? I mean, they think it's a question. It may or may not be consistent with it, but they're clearly not taking cases. They explicitly take questions.
Well, how do you think the court's modern practice of pre-selecting questions leads to kind of political polarization on the court?
So I think it happens for a couple of different reasons. So for one, you're picking out the stuff that divides people the most, right? And you're picking out the issues, not even the cases. So it's not just this is important, like what's going on in this case is really publicly important and we should really pay attention to it. It's like, oh, this issue is really, really divisive. And it's been punted to us and we should really grab it and, talk about it and whatever else and short circuit the democratic process entirely. And we'll just do that for you. So it's the court at its policymaking zenith in some ways. And so I just think it's natural that the more the court gets into politics, the more it's going to reflect our politics. I think that's just sort of natural. Even if they're not that divided all that sharply, I mean, the way people are going to take them, the way they're going to read, people are just going to say like they voted for it, they voted against it. No one's going to go read the nuanced opinions and figure out whatever else is what's happening. So I don't think that's a big deal. I mean, I think that's a big part of it. But I think there's another way too. So this is sort of like a political sciencey answer. Kyle, have you ever heard of the median voter theorem? You ever heard of this?
No, I don't think so.
Okay, so here's the median voter theorem, right? The median voter theorem says, say Kyle and I are running in an election, right? So everybody is like lined up from the most liberal to the most conservative. And you and I have to like pick where we want to stand. And the people that are the closest to us will vote for us, right? We can stand anywhere we want in this line. And so suppose like you're more conservative than I am and I'm more liberal than you. And so you start out standing closer to the right and I start standing closer to the left. Well, you figure out like, hey, if I take a step closer to Ben, then I'll pick up like one extra voter and I don't lose anybody over here because all those people out on the wings are still closer to me than they are to Ben. Even if I move closer to Ben, like, yeah, I'm further away from them, but I'm still closer than Ben is. And I figure out the same thing, right? And so we basically kind of like end up in the middle, right? Is the idea. So what happens is like in politics, a lot of times what we want to do in politics, we want to kind of like shove things to one dimension. So it's like the median voter gets to decide. And that's fine, right? Like that's generally a good thing. And I think that's why you end up with like, moderate positions coming out of the court a lot. Because, for a long time, it was whatever Anthony Kennedy wanted is what Anthony Kennedy got because he was the median and you turn everything into one dimension. And so the median got what the median wanted and that was Anthony Kennedy. But notice what this does to lawmaking, right? And I talk about this a little bit in the Alabama piece. So now suppose you and I are not like just one, individual politicians running on one thing. Suppose I'm like a really strong progressive and you're a real strong conservative. And we're trying to negotiate this big bill, right? And basically, either of us could stop it. But we have two options. We can both block it from passing, or we can basically horse trade. And I'll give you some of what you want, and I'll take some of what I want, right? And so that used to be the way you did things. But now, when we get to the Supreme Court and they take things one dimension at a time, what happens if I'm an extreme or you're an extreme, especially I think this is true. I think people on the left look at this way now. If they put something they want in the bill, they know that it's going to get challenged and it's going to go to a conservative court. And that one issue, that the one thing they got in the bill that they cared about, that got them to get on board with it, is going to get tossed because it's going to be treated on this one dimension and it's going to go to the median justice who is, Brett Kavanaugh or Amy Coney Barrett or something like that. And they're going to say no because they disagree with the squad, right? Or something like that. And so the squad has no reason to actually engage in anything that looks like bipartisan politics or whatever else. And so I think the court has this type of issue by issue targeting makes it really, really hard for legislatures to bargain. And so and what's more, they basically tell the legislature, hey, you don't have to decide any hard, important, or difficult questions because we'll decide them all for you. And you can just go on Fox News or MSNBC and raise money and whatever else, and that's fine. You know, we'll do the actual, we'll make the grown up decisions, and you go play and make money and do whatever else. And so I think that just leads to massive polarization globally, and then that redounds to the court because like they're the only game in town, for politics, and the politics more polarized, we view the court as more polarized. I should say though that like the most common outcome of the Supreme Court is still 9-0. I mean, like most of the time they agree on stuff.
Well, just to follow up on that, do you think that this political polarization is something we should try to reduce, or should we really try to take advantage of it and steer into the skid with the current composition of the Supreme Court? It's kind of a Adrian Vermeule kind of argument, common good originalist.
I mean, there's two ways you can answer this question, right? So on the one hand, you can say, do I try for my first best, or do I just accept that we live in a second best world? So, I'm old enough to remember back when the Federalist Society, and I think this is true of most people who I work with still in the Federalist Society, just honestly believed in originalism, and did not particularly care about how the cases were going to turn out. I mean, we're pretty confident that we would like most of them, but like if we were wrong, okay, right? I mean, like we had a commitment to the idea that like the Constitution meant something, and I think most of us still have that view that the Constitution means something. And if that's true, then I think my paper is trying to say this is one of the things that means, right? Like the court needs to get back in the business of being a court. And if everybody would just if the court would get back in business of deciding not 50 cases a year, but like 300 cases a year, which is, by the way, what they told Congress they were going to do. And they said this back in the day before Westlaw, Lexis, or clerks. And they did not have their own building. They literally worked in the basement of the Senate. So if they could do that back then, like there's no particular reason why they couldn't today. If they got back in that and doing that, that's a world where the Supreme Court stops being maybe a political football, and law returns to a more kind of workmanlike thing. And I'd like that. And I think that's consistent with the original vision. I think that's where we'd like to go. Now, maybe I'm a fool, and maybe that's just not where we're going to go, right? And maybe, there are enough people on the left in particular who just want to rerun the war in court. And maybe there's enough people on the right who look at Earl Warren and say, he was just the wrong kind of Republican, but he had the right idea. And want to take the court and run with it, just like the left did. And if there's enough of those people that we're just not going to be able to sustain an equilibrium around kind of like what the Constitution says, then then you're picking up sides. But I think that's a world we've already kind of said goodbye to the Constitution, and I'm not entirely convinced I'm ready to go there yet. But I don't know. I understand why people might be.
Definitely agree with you there. We have our first audience question, and it's from Nicholas Williams. He asks, can you give your thoughts on the shadow docket and how, if at all, it affects this issue?
The shadow docket. Okay, so shadow docket, fascinating topic. All right, so the first question you have to ask, at least with my paper in the shadow docket, is are orders dealing with certiorari part of the shadow docket? I think they are. And if they are part of the shadow docket, then my paper is all about part of the shadow docket. I think they're part of the shadow docket because they are definitely shaping questions. They're often the court will grant, vacate, and remand straight off of these things, which is a way of disposing of cases without review and whatever else. So they certainly seem to me to be part of the shadow docket. So I think that's definitely part of it. Now there's a whole other part of the shadow docket, and these are often motions to stay proceedings below, or lift, or make an injunction or something like that. And those are not styled those are styled as applications or motions. And so if you look at the court's docket, they start with an A or an M, as opposed to 22 dash or whatever the case may be, right? So so that part of the shadow docket is a little bit different, and there I'm very conflicted. I'm conflicted for a couple of reasons. So on the one hand, I really like it because my my objection that's kind of like animating this paper, although I don't like say it as forcefully there as I do, but hey, we're hanging out in t-shirts on the study break, is that uh, the court's just not deciding cases, and that's wrong. They should be deciding cases. That's what courts do. Courts decide cases, and they should do that. They should take a look at everything that's before the lower courts, and they should see whether they got it right or wrong. And that's kind of what they do in these applications and motions. And so that's like the most court-like that they are. Now, do people have a valid complaint that they're not getting briefing or oral argument, and so maybe they're not making the best and most informed decisions on these things as they otherwise could? Seems like a fair objection. But a lot of appellate courts make decisions on the papers or on emergency motions or whatever else. So I don't know that that's a deal ender. A paper I'm working on this summer, hopefully, is actually is kind of a follow-up to this Columbia effort, where it's kind of like, how did we get here? So here's the thing that I've found fascinating. If you go look at the applications, the petitions, like the applications themselves, and you look at the part where they say, like, where did you get jurisdiction? Like, where does the court get jurisdiction? They all say this part of 28 USC, the All Writs Act, which is a statute that says the court has the power to grant writs in aid of its jurisdiction, right? Now that's weird to me, right? Because like, it seems to me like if I have jurisdiction in a case and I need to use a writ to like do some stuff for this case that's to aid my jurisdiction, I can do the stuff. That seems totally reasonable. So classically, certiorari was a writ that allowed you to call for the full record from the course below. So I have jurisdiction in this case. I'm missing part of the record, so I'd grant cert to get the record up. Or I need habeas corpus. I need the defendant to show up so I can decide his case. Or I need mandamus. I need you to do this. I need you to fix this mistake you made, or whatever else the case may be. But like, I clearly have jurisdiction in this. It's not at all clear to me that a statute that says you can exercise a writ in aid of your existing jurisdiction is a source of jurisdiction for something else, right? So it's not at all clear to me where the court gets jurisdiction at all for these shadow docket things, unless it's through the certiorari statute itself. Now, I could be wrong about that. I mean, so there's going to require like a whole bunch of like digging through the history on this and looking to see like old mandamus cases and habeas cases and things like that, and see whether or not that's a fair reading, or whether or not kind of the original understanding of the All Writs Act included something that looks like a way of grabbing jurisdiction in a case. But I think there's a second question, and this is something I had a conversation with a colleague of mine here at Penn State Law, Jake Schuman, fascinating criminal law guy. Anytime you can read a Jake Schuman paper, you should. We had this conversation about it. So what does it mean if like it's a preliminary injunction, or if it's a, it's some, like the case is in the district court, for example, and this comes up. Like, if it comes up, but is the case really on appeal at that point? Like, in some sense, if what you're doing is, if you're taking jurisdiction over the case, but the case has not reached a judgment, it seems that it would have to be arising in the original jurisdiction of the court, because there's not an appeal, possibly. I don't know. I'm just making this up as I go along. But this is kind of where my head's at right now, which is like, is there a limit to this? So like, is it actually constitutionally proper? So in some ways you could think about like, there's, as you learn in the first week of Civ Pro, right? For a federal court to have something, it has to be constitutionally permissible and statutorily authorized. And it's not clear to me that either of these things is true for some of these appellate from these applications. I could be entirely wrong about all this. I'll find out this summer when I write the paper, and then you can have me back next year and we'll talk about it. But that's kind of that. So I've been thinking a lot about the shadow docket, and we'll just see what happens.
Okay. And now that we've kind of established that the Supreme Court is picking legal questions and not cases necessarily, do you think there's certain questions that this court's predisposed or has its eye on, really? And do you think there's any issues that the court's reluctant to address?
Well, so I think this is where I have no particular expertise other than like what I read on the web, right? So here's what I do have actually. Here's what I do know, and a lot of people know this. So the way the court grants certiorari is through what's called the rule of four. So what you need are 4 justices to take a case, right? There are a whole bunch of things that conservatives would like to see the Supreme Court do, and it appears pretty clear that Justice Thomas, Alito, and Gorsuch are very, very happy to do those things. So what that means is they've got to convince one of the other three conservatives to do it with them. And right now there just appears to be like this fight, just, with no inside information and no reading, but purely just looking at who's dissenting from denials. It sort of appears that the Chief Justice is working really hard to keep Barrett and Kavanaugh from joining and being the fourth vote on cert, because he's very unlikely to be able to stop them, or even possibly himself, from defecting, from joining them on the merits, right?
Mm-hmm.
So it seems very clear that, there's a lot that many of these people would like to do in Second Amendment area. There's a lot to be done all over the First Amendment. It's unclear how much they'd like to do in the federalism space. It's very hard for people who get all of their appointments and all their careers to the federal government to all of a sudden develop a concern for states, but you never know. The one I'm kind of interested in is qualified immunity, because there's been a really hard shift, I think, among Federalist Society, led by Will Bode and folks on the right, to kind of point out that this is court-made and absurd and kind of evil and awful, and we should try to fix it. And there's not a lot of good reason to do it, and that could kind of lead to some strange bedfellows kind of reasoning. Of course, Alito would lose his mind. So I don't really know how that plays out. So we'll see. But but the thing is, like, when these cases get onto court, like, the fact that they make the docket tells you a lot about how they're going to turn out. So.
Well, what's your solution to justices pre-selecting questions instead of deciding whole cases as they traditionally did?
Yeah, so I have a long, convoluted, like, kind of Rube Goldberg machine. So I'll try to lay it out for you like this. So you start with this: I follow the law. That's the deep thing, right? So the deep thought is follow the law. You either take a case, and like all of these people, with the exception of Justice Kagan, were judges on circuit courts and know exactly what the job is, right? All of these people know what the job is and just do the job. That's very easy. Alternatively, if you want to take questions, you should allow circuit courts to certify the questions to you, because that is literally, if you go back and you look at the history, that is what Congress thought the Supreme Court was going to be doing. They thought most of the business was going to be these certified questions, and certiorari was only a backstop. It was like, only if the circuit judges are really, really negligent or kind of doing something shady and not certifying the questions they should, in that rare instance, you could use certiorari to bring up a case, right? But then you had to bring up the full case. So they could go back and say, listen, if we need to be in the question answering business, then the lower court judges, who are actually the ones who are doing all of the work and see the types of questions that are really creating problems on the ground, and we're struggling with, like, they should send us those questions, right? That's what Congress designed. And they could go back to that if they want to be in the question answering business, or they could go back and answer cases. But my long thought out answer is follow the law.
I think that's a pretty good answer. We have a question from the audience from Ellie Bielman. What advice would you give to a graduating 3L?
Study for the bar. But don't overstudy. You just got to pass. That's the thing. So I will say that, like, as I've gotten older, the thing they tell you in when you get to a law firm that they do not tell you in law schools, which is a shame, is that your reputation matters a lot, right? So the reputation you develop as someone who is a good writer or a bad writer, someone who thinks clearly or doesn't think clearly, someone who meets deadlines or doesn't meet deadlines, someone who is honest or is kind of, cutting corners. Like, those things matter a lot. And reputation gets out. You got to be really careful. And so some of the things when I look at what's going on in law schools, it was weird to me. So, like, when the whole thing happened at Yale, and then the circuit, when the judge emailed out like, hey, we should probably keep an eye on who these people are. Maybe we shouldn't make them clerks. And I was like, that's almost the biggest duh thing ever. Like, because reputation matters, right? Like, this is of course, like, what did you think was going to happen when you made a fool of yourself in front of everybody else? Like, I mean, like, you just don't get to do that if you're a lawyer, unless you're a certain type of lawyer, unless you're like the Michael Avenatti type of lawyer who makes your career off of being a fool in front of other people, right? There are people who like use their JD as a sort of like, I'm going to be kind of a bleeding edge advocate, and I'm just like, no one should take me seriously as somebody who is like an officer of the court or committed to the pursuit of truth or whatever else. You should take me to be like, a knight in shining armor going out after to save the maiden that I have discovered, is in need of saving. And that is the only thing I care about in this world. And I certainly don't care about you. If that's you, God bless you. And we need people like that. Don't get me wrong. Like that's a good reason to go to law school. Don't get me wrong. So if that's you, go ahead and do it. But that's a different thing. But most people, if you're going to be a lawyer, you have to work with people that you don't like, and you need them to work with you. And so that means you got to be a decent stand-up person, and you got to be responsible, and you got to be respectful. And it's basically you got to do all the stuff that your mom should have told you should do. And hopefully your mom did tell you those things.
I definitely agree with you, because how people perceive you, or at least even being in the Federalist Society and meeting all these great contacts, how you kind of carry yourself and that image you put out of yourself is really important. I agree.
Yeah.
If you could go back to law school, what do you think is one thing you do differently?
That is a good question. Man, that's a really good question. I think because I turned out to teach corporate law and I took corporate law, but I didn't take like hardly anything else related to corporate law. I probably would take some more corporate law related stuff just because so it turns out that I hated corporate law when I was in law school, but now I love it. I think corporate law it's the one class in law school where we teach students how to build institutions that will make the world a better place even after you're gone. Everywhere else in law school, your client something went horribly wrong and you're trying to pick the pieces back up and put them back together, or in some transactional practices, like here's this thing, we're going to do this deal today and we'll move on to the next one tomorrow. But like corporations is institution building. And that's like really special and cool. And so I wish I had spent more time thinking about that. Yeah, I think that's important. I also think that I had taken a bunch of I'd done a bunch of accounting in a previous life before I went to law school, but I think I should have spent more time trying to figure out how accounting and law intersected. And I think if anybody's like looking for like a skill they could sort of pick up or something they can get on the ground floor now, like whatever you think of ESG stuff, like environmental stuff in corporate law, the world is absolutely moving to a place. The SEC is about to mandate all the corporations have to include environmental sustainable goals like in their quarterly filings and stuff, which means people are going to make this stuff up. Like there's no good way to do this. People just have to make it up and they're going to put it in there. And there's understanding how that is evolving and how that is happening. And being on top of that there's a lot of money to be made there. And it's all made up. So you basically can spend a couple of days on Google and basically be caught up to just about everybody. And so that's a really interesting area, I think, going forward.
You said you didn't like corporate law, and when you're actually in law school, did you have an idea of what you wanted to do before law school, or when did you know that what did you want it to do?
Yeah, so I went to law school. So my dad's a pastor, and I care a lot about like religious freedom for exercise stuff. So I came to law school and I really wanted to be like a First Amendment litigator. It's like what I really wanted to do. And then I went to this lunch because it was free my first year, and it was like, so would you like to be a law professor? And I was like, I don't know, I just want your free lunch. And they told me what life was like as a law professor. And I was like, oh yeah, I want to do that. That sounds fascinating. So I thought maybe I could do both of these things. Maybe I could be a law professor who writes about free exercise stuff. And what I figured out really quickly was I cared too much about it to be able to write about it well. Because I was too passionate about it. So my writing was just straight up advocacy, and it wasn't like dispassionate scholarship. It's really, really hard. My colleague Mark Storsley can do that. He cares a lot about it, but he is able to be a dispassionate scholar on the topic, and he's excellent at it. I am not that good. Mark is just better than I am at that. And so he's able to do it. I was just not. So it was very clear to me that if I was going to be a scholar, I was going to have to find something that I was good at, but I didn't care about. Or that I didn't care that much about. And so I needed to care enough about it that I could spend my time on it, but not so much that I'd be royally pissed off if somebody disagreed with me. And so I came into political science and Supreme Court agenda setting and judicial politics, and I do a bunch of like game theory and machine learning and other stuff like that in my day job. And I teach corporations and work on papers like, on game theoretic models of fiduciary duties and stuff like that. Because, it's like, I mean, I find it interesting, but I'm not like passionate about it in the way I am about, some other things. And so I'm able to hopefully do some good work.
Are you still dabbling in the religious liberties kind of area, or at least keeping up with that stuff?
No, I think it's one of those things where I thought it was, but there are now enough people who do it and do it well that I feel like, and they do it better than I could, that it's just not, I wouldn't be adding value if I was doing that. So, I've got 3 kids. I've got a wife that I love. I've got students that I care a lot about. I've got research that I want to do well. And so that's just one of those things that I just don't get to, I had to kind of say goodbye to in the past.
Well, how's your diet going? You and me have talked before.
Oh yeah. So right. So Kyle and I were talking about this. So I was on one of this stupid, very sad diet where I was like eating nothing but egg whites, grilled chicken, and protein shakes, and I was only getting 750 calories a day. And I made it like 9 days, and I was doing fine. Like I was feeling okay, except I couldn't think straight. I could not remember names. I could not like remember what I was supposed to do. All I could do was watch television. It was very sad. And then I realized that I had to give a 2.5-hour guest lecture last night. And then immediately after that, I had to present a working draft of my corporate law paper. And I was going to have to do all this back to back. So it was going to be like 4 hours solid. And I was like, there's no way I can do that when I'm in this brain fog. So the diet ended yesterday at noon. And I'm able to be here today and finish sentences, which is very nice because it was actually in question yesterday morning when I was undergoing the diet. So it was initially successful. Lost the first wave was successful. Lost some weight. I'll try to like keep the calories reasonable for a few weeks, then I'll go back and suffer again for another 10 days or so. And so I was telling Kyle my 20th anniversary is coming up in November, so I'm trying to be unfat for that come November. That's the plan.
Well, I actually have COVID-19 right now, so I definitely understand you on the brain fog thing. But yeah. I'm glad you're here and speaking with us very cogently.
Yes, it was a narrow thing, but we got it down. I will say that the rice I had tonight on my Mexican cheese like quesadilla bowl type of thing was fantastic. Oh my gosh, I was like, rice, oh gosh, it's so good.
I saw that you before we started the call I saw you have a guitar case behind you.
I do, yeah. So I play guitar at church is my thing. So I'm a mediocre to good acoustic guitar player, and I own an electric, so I'm the lead electric guitar player at church. So it's a very sad thing, but so I'm hoping we actually have a guy in the church who's a professor of classical guitar, and I'm like, John, you've got to get in here. Like, what am I doing here? Get up here and play. It's like my wife just had her 4th kid. Like I can't get in here. I was like, fine, you got 6 weeks. Get up here, come on, So I'm always actively recruiting. If any of you play guitar or drums and find your way, find yourself in a legal career in State College, Pennsylvania, we are looking. We could use the help. So.
Well, how long have you been playing guitar for?
Oh gosh. 25, 30 years.
Wow.
Yeah. So my dad told me, when you go to Baylor, I was like in 8th grade, when you go to Baylor, you need to be able to play piano and guitar so that you will be able to meet women, is what he told me. My dad, again, is a Baptist pastor. And it worked. I met my wife 3rd day of class freshman year playing piano in North Russell lobby. I was playing the piano. She came down, she kicked me off the piano because my wife is a concert pianist. She played the piano, humiliated me, and I decided if you can't beat them, join them. And we've been together ever since. So
Fair enough.
So
Another
dad
question.
gave me good advice.
Another question from the audience. Could you point us towards more of your work concerning game theory and machine learning?
Yeah, so if you can find my dissertation online, it's actually available somewhere on Google. There's a paper in there on game theory that's a sort of like an early version of a model about how the idea is actually how the Supreme Court kind of fills up its docket for the year. It turns out that unless you put a lot more structure on the model, you can't actually solve it fully, and so the paper is kind of like we got it to a certain point and just kind of had to leave it there because we had to make some really hard choices at that point. We just ran out of room and time. I'm submitting a game theory paper, or a formal theory paper, not game theory paper, a formal theory paper, hopefully next week with a colleague, Richard Jordan at Baylor on, and anybody who's interested, just shoot me an email. You can find my email on my school website, or it's bbj14@psu.edu, and I'll send you the draft. But it's a formal account of like cases should be decided alike, and we formalize it and write it down and say this is what it means, and it actually leads to some really strange, surprising, and terrifying results, which is kind of interesting. And then I'm working on this paper that's the formal model of corporations, and I'm happy to send that to somebody if they're interested. Yeah, and all the other stuff I've got are kind of like models. If you've ever written a game theory model, you get to a point where you like basically solved it, and then you're so sick of it you don't want to write it up. And so I've got several in that. And the machine learning stuff, I'm actually working on a book. We have the empirical chapters were done today. We actually just my co-author and I like emailed our first drafts of our respective chapters to each other today. But it's a paper, it's a book about the Supreme Court and its relationship to public opinion and public mood. And so we use random forest models to see whether or not information about public mood affects justices or the Supreme Court's decision making in cases. And we show that it does not. So basically, they don't care what you think. Maybe that's a good thing, that's a bad thing, but I think a lot of people thought they do, and we show, I think, pretty convincingly that they don't, and we get to use some fun machine learning models to do that. So that's a bunch of fun things. And if you're into that type of stuff and you would like to work on things, you should totally email me, and we should get to work. It'll be fun.
All right, last question for you, Professor Johnson. Fun fact about you that not many people may know, especially from looking at you on Zoom, but you're 6'5".
I am.
So what's the best and worst part about being so tall and towering above others?
Okay, so airplanes totally suck. Airplanes totally suck. And also sucks like in our 2-car garage, like so my parents are visiting, and so when they drive our minivan, they like park too close like to the middle. So when I try to get out, like unfolding is really, really awful. So like, getting in and out of small spaces is by far the hardest part about being tall. Best part of being tall, like it's really easy for my family to find me in crowds and stuff. It's pretty easy, especially because my hair is kind of big, and so like when you include the hair, it's a good 6'8", 6'9", right? So that I'm wearing shoes and got big hair. It's like, yeah, you can find me anywhere. So that's fun. I'll say that the time that being tall like was surprisingly hard for me was I was actually a cheerleader in college. Not for any good reason. My best friend was the captain of the cheerleading squad, and she told me that they were going to have to close down the squad because all the guys were academically ineligible. And as a joke, I was like, "You're so desperate, you'd probably take me." Ha ha ha. And she said, "Practice are Tuesday and Thursday at 7:30. Be there." So I showed up for a semester and I cheered for Baylor basketball. We were terrible back then. We're phenomenal now. We were absolutely awful back then. But it turns out that like when you're tossing, a flyer into the air, gravity doesn't stop working just because you're tall, right? So all of, it turns out the other guys were able to play, come out, and they were all like 5'8" to 5'10". I'm 6'5", so I've got to keep throwing these people up another 7 inches, and gravity's working against me the whole time, and it was just brutal. And so, and then these poor young women were up there, and they're like, "I'm so high!" They were screaming. It was just like they're completely freaking out, and they just like the line messed up because everybody's like this, and all of a sudden, boom, there's Johnson's person, and then back down. And so that was the other time that I was not ready for it to be a problem, but it was. So.
All right, thank you so much, Professor Johnson. We really appreciate you taking the time to speak with us.
Well, thanks for having me.
And thank you all of you for joining us tonight. We hope you'll join us for the next FEDSOC study break on constitutional law, and that'll be on May 3rd and hosted by the Georgetown Law School chapter. Thank you, everyone.